Traffic, daycare, carpools, family time. There are many reasons why many workers favor alternate work schedules or something called flexible work hours. What's the difference? How can you take part? And under what circumstances can management take it away? Hi, welcome to the California Statewide Law Enforcement Association. I'm Communications Director Terry Cox, and with me is Legal Counsel Andrea Perez. And our members, our state workers, they're in a lot of classifications. It's not a 9-to-5 world, so there are a lot of questions about work schedules.
Right. We get contacted a lot by our members from various types of departments, whether they work 24 hours or they work 9 to 5. They want to know about a different type of schedule that they can have. And our contract allows for alternate work schedules, or I like to say AWSs for, to shorten it, and also allows for flexible work schedules, and there are a difference.
There's a difference. So let's talk about the alternate work schedule first.
So an alternate work schedule usually applies to members that work in a 24-hour operation. So your dispatchers, your communication operators, hospital police officers. There's 3 type of alternate work schedules typically. The first, a 9-8-80, which is you work 9 hours a day and can have every other Friday off or every other Monday off. Or a 4-10, where you work 4 days, 10 hours a week. And then the other is a 3-12, which is 3 days a week, 12 hours a day. And then the following week you would work 3 days a week, 12 hours a day, and have an 8-hour day.
That said, what is flexible work hours?
So flexible hours usually apply to our investigator classifications, some of our people who work in office, and that's usually they can work 7 to 4, 7:30 to 4:30, 10 to 6, as long as they work core hours. So usually those core hours are 10 to 2.
It would be nice to come and go as you please at work, but we all know there has to be some order in the workplace. So there are rules to govern alternate work schedules and flexible work hours.
Article 7.2 of our contract is what deals with this, and it's very important that people read it. One thing to remember, everybody needs to remember that the state reserves the right to schedule at their work location to the best of what fits their needs. So really, the state ultimately preserves and has the rights to decide scheduling. But that being said, some classifications in our contract, particularly public safety dispatchers, for example, that work for the highway patrol, can vote in an alternate work schedule at their work location. And it's usually done by a 2/3 vote. Management does have to approve, but usually the employees can initiate the schedule. And the state can also order an alternate work schedule or flexible work hours if they need to fit their needs.
I imagine, Andrea, once you have this, you absolutely love it and you don't want it taken away, but this can be taken away.
That's true. 7.2 also discusses the criteria that the state has to follow when polling an alternate work schedule or flexible work hours. This usually deals mostly with alternate work schedules, and there's the 3 things the state has to do in order to pull that schedule. The first thing they have to do is give the employees and CSLEA a 30-day notice. Then they also have to provide us the opportunity to meet and confer to discuss the impact. So that means they notice us and we set up a meeting with the department and say, okay, why are you pulling this schedule and what's the impact going to be on our employees? And the third, most important piece of it is that they cannot pull or amend a schedule for arbitrary and capricious reasons.
So what is your role in this? When might a member call you to ask you about this situation?
So usually members call us when their schedule is being threatened. And in that situation, CSLEA is allowed to, in some circumstances, file a grievance and potentially arbitrate the issue. So we get involved with the meet and confer process, and then we would get involved with deciding the arbitrary and capricious question. We've arbitrated this issue several times throughout the last several years, and we've gotten some favorable decisions from arbitrators. The state has to provide a reason they're pulling the schedule, and they have to have evidence to back that reason. Simply saying, because we feel like it, doesn't qualify as arbitrary and capricious. But there are some reasons that are not arbitrary. Those are if there is excess sick leave, if there is excess overtime abuse, mandatory or voluntary, if they're just having to use a lot of overtime. And if the state can tie those 2 things or 3 things to the schedule, it's not arbitrary and capricious, and probably in that reason, we wouldn't file a grievance. But we're going to be asking the state to show us their numbers on that.
And then is there any burden on the employee to prove that this isn't a problem, this work schedule isn't a problem?
Absolutely. So if the employee comes to us and says, hey, we really want to keep our schedule, and the state is claiming, oh, we're using sick leave, oh, there's too much overtime, I'm going to say, okay, show me from your perspective why they're wrong. And if the employee can come to me with their timesheets, they can interview their coworker and say, okay, how much sick leave are you using? And if they can show me that, you know what, these reasons the state is saying isn't tied to the schedule, they could be legitimate problems that are existing in the center, but it has nothing to do with the schedule, they've got to show me that. The employees have to have that responsibility because I don't work there, so I don't know what's going on.
And employees love these type of schedules, so it's hard to believe there's actually a downside to these schedules, but you're telling me that there could be.
There definitely could be. There are some things that come into play that employees need to consider when they want an alternate schedule, when they want to vote it in or not, get rid of it. The contract actually requires that employees hold something called excess or a certain leave balance because every state employee, which most people should know, are required to work either 168 hours a month or 176 hours a month. It just depends on the month. And the Cal HR will put out a schedule and you'll see which month is which. So sometimes because of the way these schedules fall, an employee may not hit that hourly requirement by the end of the month, whether it's they were sick or a certain scheduling. And so if you're short that 176 or 168, you have to borrow from yourself to basically make your paycheck. So you could be pulling from your vacation, your annual leave, your holiday credit to fill in your timesheet. You can't use sick leave though to get those hours.
And certainly if our members have any questions, no matter how small, you're here to take their phone calls.
Absolutely. Alternate work schedule revocation and actually putting it in place can be kind of a tricky situation. Again, not every place can vote it in. They can ask for it. There's different things that they can do. And so always call us because we will guide you through that process.
All right. Thank you, Andrea. We are here for you. We have an office in Southern California, an office in Northern California. You can call us or you can email us, and we do look forward to hearing from you. Thank you.